Hey everybody, it's Ron, and I want to tell you a story about business and how that story changed everything. A young woman seated in the front row has just finished third in her class out of 102 students. Third. She served on the Stanford Law Review and was inducted into the Order of the Coif, the highest academic honor in American legal education. The student who finished first in that same class, a fellow Arizonan named William Rehnquist, walked out of Stanford and straight into a clerkship at the United States Supreme Court in Washington, D.C. That path was not open to this lady. So she started applying to law firms. She applied to firms in San Francisco and Los Angeles, the same firms actively recruiting her male classmates. Most didn't even respond at all. Several wrote back to tell her they were not hiring women lawyers. One firm in Los Angeles, Gibson, Dunn & Crutcher, agreed to meet with her. She went in with her credentials, her class rank, her law review experience. They offered her a job as a legal secretary. And she said no. Instead, she wrote a letter to the county attorney for San Mateo County in California, explaining why she thought she could be useful to his office. When he told her there was no funding for another deputy, she offered to work for nothing. He gave her a desk she shared with the secretary and a title, Deputy County Attorney, and no salary. She showed up anyway. This young lady built the career that nobody else would build for her. Assistant Attorney General in Arizona, State Senator, the first woman to serve as Majority Leader of the Arizona State Senate, a judge on the Arizona Court of Appeals, each position in a system that had made clear at the very start that it wasn't looking for her. So how do you walk out of one of the finest law schools in the country, credentials in hand, and absorb that kind of rejection from a profession you were more qualified to enter than most of the men already inside it? How does a system that refused to hire a woman as a lawyer eventually reckon with what it lost and what it signaled to every woman watching from the outside? And how did all of that come into full relief on July 7th, 1981, when President Ronald Reagan nominated Sandra Day O'Connor to the United States Supreme Court and the Senate confirmed her 99-0? From Business Basics, I'm Ron Trucks, and this is Business History, the daily podcast where we explain the stories that changed business forever. Every date on the calendar has a story where business reshaped the world. Today, July 7th, that story takes us to 1981, the first woman on the court. When Ronald Reagan promised during his 1980 presidential campaign to appoint the first woman to the United States Supreme Court, the reaction was mixed. Conservative allies who had helped elect him were immediately uneasy. Reverend Jerry Falwell said he was troubled by the idea. Several Republican senators called the White House to register their concern before a name had even been announced. Reagan made the appointment anyway, and on July 7, 1981, he nominated Sandra Day O'Connor to replace retiring Justice Potter Stewart. Now, the person he chose was not a compromise candidate. O'Connor had served as Deputy County Attorney, an Assistant Attorney General, a state senator, and the first woman, as I mentioned, to serve as Majority Leader of the Arizona State Senate before her appointment to the Arizona Court of Appeals. Her record was that of a moderate conservative, someone who had operated effectively inside institutions that weren't always designed with her in mind, and who had built a reputation for pragmatism over ideology. In 1981, women represented roughly 14% of American lawyers. The professions that write the rules, law, finance, medicine, were still overwhelmingly male at the institutional level. The question O'Connor's nomination raised wasn't just symbolic, it was structural. What does it signal to an entire professional ecosystem when the highest court in the country seats someone who had been offered a secretary's desk by a firm that wouldn't hire her as a lawyer? The Senate answered that question on September 21, 1981. The confirmation vote was 99 to nothing. Even the senators who had called the White House to complain voted yes. Whatever reservations existed behind closed doors, not a single member of a deeply divided Senate could find a public argument against putting Sandra Day O'Connor on the Supreme Court. O'Connor joined a court that had its divisions, but she arrived at its center and stayed there. In her early years, she voted reliably with the conservative bloc, Berger, Rehnquist, and later Antonin Scalia, and was described consistently in the press as a classic conservative. What changed over time wasn't O'Connor, though. The court moved around her, growing more ideologically defined on both sides, and she declined to move with it. She became, to her admitted irritation, the swing vote. Between 1994 and 2004, she voted with the majority in 135 out of 175 cases, which were decided 5-4, more than any other justice. Sometimes that fifth vote leaned conservative. Sometimes it leaned the other way. What it almost never did was follow a predictable ideological script. One legal scholar later described her as someone who would be seen as too much of a wild card to be nominated today. The conservatives who had opposed her nomination came to see her as a warning about what happens when you don't demand a movement vote. She was unbothered by all of that characterization. Her first major opinion set the tone. In 1982, O'Connor wrote the majority opinion in Mississippi University for Women versus Hogan. It was a case involving a man denied admission to a traditionally all-female nursing school in Columbus, Mississippi. The vote was tied 4-4 before O'Connor cast the deciding fifth vote. She ruled that the school had to admit qualified men, reasoning that excluding them perpetuated the stereotype that nursing was exclusively a woman's profession. Her first major gender ruling cut against gender-based exclusion in both directions. That was the lens she brought to the bench. For the business world, the consequence of O'Connor's position at the court's center was this. For 25 years, the rules governing employment, professional access, and workplace standards in America ran through her vote, often enough that the legal framework American businesses operated inside was shaped, case by case, by someone who had once been told the best she could hope for was a desk in a law firm's secretarial pool. Oh, and here's a piece of information. Gibson, Dunn, and Crutcher, the Los Angeles firm that offered her that secretary's position in 1952, called her decades later to ask if she would keynote their 100th anniversary celebration. She said yes. The signal effect of O'Connor's confirmation moved through American professional life in ways that are difficult to isolate but hard to dismiss. By the mid-1980s, women were entering law school at rates that would have been unrecognizable in 1952. The same shift was visible in medicine and finance and executive leadership, not as a straight line, not without resistance, but as a measurable directional change. An institution as visible as the Supreme Court doesn't just make rules. It tells a story about who belongs inside the rooms when the rules get made. O'Connor told that story for 25 years from the center of the court. casting deciding votes on employment discrimination and affirmative action, professional access, and the boundaries of institutional authority. A pragmatist who evaluated cases on their specifics and reached conclusions that satisfied neither side completely, which is exactly what made her consequential. A predictable vote is a known quantity. A genuinely independent one reshapes the terrain. In her later years, O'Connor said publicly that she was concerned about the increasing partisanship of the confirmation process and the erosion of the judicial independence she had tried to model. She said it not as a partisan, but as someone who had watched the system from its middle for a quarter of a century. She retired in 2006 and passed away in Phoenix, Arizona on December 1st, 2023, at the age of 93. Oh, and William Rehnquist, her Stanford Law classmate, the student who finished 2 spots ahead of her in 1952 and walked straight to a Supreme Court clerkship while she volunteered unpaid in San Mateo County, became the Chief Justice of the United States in 1986. For the next 19 years until his death in 2005, he and O'Connor served on the same court. The system that had sorted them so differently at the starting line put them side by side at its center for nearly 2 decades. What it took to get there, for one of them, was a little longer, and a letter offering to work for free. I'm Ron Trucks, and this is Business History, the podcast that finds the turning points behind the headlines. To hear more stories like this, follow us on Apple Podcasts, Spotify, YouTube, or wherever you listen. And if you're enjoying the stories, don't forget to subscribe and leave a quick review. It helps more people find the story behind the business. And if you want to actually understand business better without the fluff or the buzzwords or the MBA language, start by visiting us at businessdailypodcast.com.